you, gentlemen. We'll hear arguments next in 73-78, Kahn against Shevin.
Ginsburg, you may proceed whenever you're ready.
Mr. Chief Justice.
If you'd like to lower the lectern, you're quite at liberty to do so.
Mr. Chief Justice, and may it please the Court. Appellant Mel Kahn, a Florida resident, is a widower. In January 1971, based on his status as a surviving spouse, he applied to the Dade County tax assessor for a property tax exemption. The statute under which widower Kahn sought exemption provided a widow, along with disabled persons, is entitled to exempt $500 yearly from her property tax. Mel Kahn was denied the claimed exemption solely on the ground of his sex. Requesting judicial review, he alleged that the statute under which he claimed exemption had been interpreted and applied in conflict with the equal protection guarantee of the 14th Amendment.
Actually, he didn't allege that in the trial court. Didn't he expressly say they didn't want to raise this federal question there?
In the original complaint, he suggested that he might save out the federal question till a later time, but then the federal question was raised and decided with the agreement of all parties.
But he didn't simply say he might save it. He said he wanted to save it, didn't he?
Yes, but apparently, with the understanding of the court and the agreement of both sides, the federal question was heard and decided both in the trial court and in the court and in the Florida Supreme Court. Appellant sought a declaration that the exemption provision is unconstitutional insofar as it excludes widowers. On cross motions for summary judgment, the Court of First Instance held that the statute, by according exemption to all widows and excluding all widowers, discriminated arbitrarily between widowed persons and therefore violated the equal protection guarantees of the state and federal constitution. On appeal, the Florida Supreme Court reversed. The Florida Supreme Court held that the distinction between surviving spouses, though based solely on gender, did not deny to any person the equal protection of the laws. It is appellant's position that the gender-based distinction upheld by the Florida Supreme Court discriminates invidiously in two respects. First, most obviously, it discriminates against men who have lost their wives. More subtly, but as surely, it discounts the contribution made to the marital unit and the family economy by the female partner for her death occasions no exemption for the surviving spouse. By defining the exempt person as widow rather than surviving spouse, this provision, now covering the blind and the totally disabled along with the widow, is kin to a classification delineated by the president of one of our nation's leading educational institutions. Anticipating an increase in conscription not too many years ago, this distinguished educator complained, "We shall be left with the blind, the lame, and the women." This court's decision in Reed v. Reed, 404 U.S., and its judgment in Frontiero v. Richardson, 411 U.S., indicate genuine concern to analyze sex classifications free from the generalizations of the Victorian age. Appellant maintains that the Reed standard is not met by a surviving spouse tax exemption that uses gender as the sole criterion for qualification. For if need is the concern, then sex should not be a substitute for an income test. And if widowed state is the concern, then it is irrational to distinguish between taxpayers based on their sex. Far from constituting a rational shorthand for distinguishing between taxpayers on the basis of need or life situation, a widows-only classification is a crude device that originated in and today perpetuates Victorian assumptions concerning the station of men and women. To resolve this case, the Court need not go beyond the scrutiny employed in Reed and followed by the Tenth Circuit in Moritz v. Commissioner 469 F. 2nd. The decision in Reed and the judgment in Frontiero indicate the Court's clear willingness to give sex classifications more than surface examination. However, if the Court wants to consider application of a suspect classification doctrine, then it must face the fact that problems of race and sex discrimination are often different, and that neither women nor blacks are aided by lumping the two together for all purposes. Thus far, this Court has applied the label suspect classification only in opinions involving discrimination hostile to groups not dominant in society. But whatever may be said for a one-way suspect classification doctrine in cases involving racial discrimination, a one-way approach in sex discrimination cases would be fraught with danger for women because of the historic tendency of jurists to rationalize any special treatment of women as benignly in their favor. With respect to race, the effects of officially sanctioned segregation are still very much with us. But complex doctrines directed to the continuing impact of racial segregation are not necessarily applicable to sex discrimination. The difference is perhaps best illustrated with respect to the educational experience. Most public education is coeducational, though females have been segregated and restricted in some areas, most notably vocational training and athletics. But generally, females participate with males in academic programs in elementary and high school, and in fact tend to do better there than males. For many females, this record of achievement continues into college and university. For example, females outscore males on the law school admissions test. The problem for women is that along the way, an attitude is instilled insidiously. This attitude is described in a nutshell in graffiti etched on a college library carrel in the early 1950s. The epigram reads, "Study hard, get good grades, get your degree, get married, have 3 kids, die and be buried." From the first line, the sex of the writer is impossible to determine. From the second, her sex is impossible to mistake. To cure the problem felt so acutely by the young woman who wrote those words and so many others like her, the law must stop using sex as a shorthand for functional description. It must deal with the parent, not the mother, with the homemaker, not the housewife, and with the surviving spouse, not the widow. To appreciate the character of the challenge classification, the widows-only exemption must be viewed in historical context. The exemption became part of Florida's law in 1885. At that time, indeed well into the 20th century, Florida law routinely differentiated between the roles of men and women, and particularly married men and married women. Women could not vote, nor did they serve on juries, for example. Well past the middle of the 20th century, in fact, up till 1968, a Florida married woman could not transfer even her own interest in real property without her husband's consent. Not surprisingly, the married woman was deemed worthy of special solicitude. On the death of the person, the law regarded as her guardian, her superior, not her peer. While the widow's-only exemption was designed with the 19th century status of married women in mind, the Florida Supreme Court found contemporary justification for it in this unquestionable fact: women workers as a class do not earn as much as men. This well-known and still wide earnings gap, according to the Florida Supreme Court, supplies a fair and substantial basis for the tax classification widow rather than surviving spouse. But beyond doubt, a widow's-only exemption has no impact whatever on the conditions responsible for the earnings gap.
Too clear. You are arguing that sex ought not be treated as a suspect classification.
I am arguing that first, that it is not necessary to deal with that question in this case, but second, that if sex is treated as a suspect classification, which I think properly it is, then the court must be aware that the argument that we give special scrutiny only to lines that appear to disfavor women will be ultimately harmful to women, because the history has been.
So it's suspect plus.
It is the classification, it is the criterion sex that is suspect, not female, but the criterion sex.
Generally, isn't it the fact that the court has found classification to be suspect when it involves a discriminatory classification against a minority group?
Yes.
Is that accurate?
In this court's precedent, the suspect label has been used.
The paradigm is race.
Yes, and national
minority race.
Yes. And what was looked at was
alienage is another, presumably, right?
Alienage, yes.
So the suspect classification is defined only with respect to discriminatory classification against a minority group. Is that correct?
That is how it has been used in this court's precedent.
Traditionally, up until now.
Yes.
And your point, I gather, is that I don't know that you've mentioned it, but women, first of all, are not a minority group. And secondly, since courts have been in the habit to view any classification of women as a beneficent provision, courts should be on guard and not...
Yes, my point is that for women, what will aid women most is not looking to see whether a classification is benign or invidious, but whether it is a sex criterion as a shorthand for what should be a functional criterion.
In other words, you don't want it whether it helps you, even if it helps.
My question is if it ever does help. Yes.
But even if it does, you would assume, on that assumption...
Well, I have not yet found any such classification in the law that genuinely helps. From a very short-sighted viewpoint, perhaps, such as this one, yes. But long run, no. I think that what women need is, first of all, a removal of exclusions and restrictive quotas. They are the only population group that today still faces outright exclusions and restrictive quotas. And then what is necessary is a welcome sign, a notice that in the professions, in trades and occupations, women are now as welcome as men. But the notion that they need special favored treatment because they are women, I think, has been what has helped to keep women in a special place and has kept them away from equal opportunity for so long. In other words, take this exemption. It's not the purpose of this exemption to eliminate discrimination against women. It isn't the purpose to eliminate discrimination in pay or to equalize training, study, job opportunities for them. In stark contrast to this widow's exemption are measures that are realistically designed to promote equal opportunity, free from gender-based discrimination. Title VII of the Civil Rights Act of 1964, for example. These measures focus on eliminating sex typing of this very order as the essential task. Nor can an exemption of this kind be regarded as a rational welfare measure to alleviate the effects of past discrimination against women. As a welfare measure supposedly directed to the ability of women property owners to pay taxes, the exemption is incredibly designed. It encompasses the independently wealthy widow, and at the same time, it excludes the woman who encounters perhaps the sharpest discrimination, the female head of household who never married. In sum, the classification is obviously unrelated to any biological difference between men and women. It is not fairly and substantially related to the need or life situation of the individual man or woman, but it is very much related to underestimation of the woman's contribution to the family economy. Significantly, the Florida Supreme Court on other days has demonstrated its understanding of the very real and substantial economic contribution made by the female partner, whether as homemaker, through gainful employment, or as is increasingly the case, through productive effort both in and outside the home. In Lithgow...
Well, as far as the statute does not differentiate among various widows, various categories of widows, it's very typical of tax legislation generally, isn't it?
Yes,
I mean, certainly the federal income tax, which gives every taxpayer an exemption of $750 for each dependent, regardless of his circumstances or the dependent's circumstances. If he's below a certain age, is certainly a very blunt instrument. And insofar as this legislation fails to discriminate as among various categories of widows, you don't really attack it, do you?
The classification surviving spouse is a well-known classification in both state and federal tax law. It does reflect the legislature's recognition that loss of a spouse is a unique episode in a person's life, and I am not challenging the classification surviving spouse.
No, my point was, perhaps I didn't express it very well. You, a few moments ago, spoke and said that the legislation is applicable whether the widow be a millionaires or whether she be a poor working widow, and whether she have children or not have children, and so on. I didn't really understand that your basic attack upon this legislation was premised upon that foundation.
That's right. I am not suggesting that the tax assessor call in each individual exempt person and see if that person really needs the exemption. Not at all.
I didn't think so.
What I am suggesting is that the sex criterion is invalid.
Ms. Ginsburg, assuming I agree with everything you said, how do you get any relief in this case?
Well,
assuming that we declare
yes.
the statute unconstitutional.
Yes. Well, if this court...
Who gets any relief then?
Mel Kahn gets the tax exemption for the tax year in question.
How?
First...
I said if we declare the statute unconstitutional.
Insofar as it discriminates against widowers, I think that if you declare the gender line unconstitutional, which is the only thing that the court has been requested to do, then the Florida Supreme Court should be free to consider whether total demolition of this exemption or repairing it to fit the constitutional requirement is preferred.
Assuming that they just end it, then nobody gets anything.
For the future, widower concept
there's a case
exemption...
in this court which says that that's not for the courts to do. The case of Cummings against the Board of Education in Georgia, 1914 or so.
Yes, I'm sorry that I'm not familiar with that.
Well, it's a case where, just like this, you wanted to knock out.
Yes?
And this court said that if you do that and nobody gets anything, that's not the proper place for an equity court to act.
I'm asking this court to take the same approach that was taken in Frontiero last semester. where a group of service spouses, in that case husbands, did not qualify for the exemption because the statute excluded them. And all this court held was that the statute was unconstitutional insofar as it excluded that class.
And this court has plenary jurisdiction over the federal jurisdiction over the federal army.
Yes, but ultimately...
And we do not have it over the state of Florida.
Ultimately, of course, that is a question for the Florida Supreme Court to answer, and it can answer that question for itself. But it would
And you'd be perfectly satisfied if the end result of this case is that the widows get nothing.
No, I do not think that that would be the reasonable approach for either the Florida Supreme Court or the Florida Legislature to take. There's a further problem here that...
Well, of course, if the end result is that everybody gets an exemption, that's the same as nobody getting an exemption.
But all widowed persons get the exemption, and we're talking about a very small addition, since there are about 4 times as many widows in Florida as widowers. I suppose that a reasonable legislature, looking at that larger class and wanting the exemption for that larger class, would extend it to this much smaller group rather than demolish it altogether.
Brother Marshall suggests that is a question ultimately up to the Supreme Court and or legislature of Florida.
Yeah, that's quite correct, yes. All we ask of this
Unlike
court...
Frontiero in that respect.
We ask this court to declare the statute defective in that it excludes widowers. And the remaining relief would be an appropriate question for the Florida Supreme Court.
Ms. Ginsburg, pursuing this discussion, do I understand you to say that the Florida court would have not only authority, but I think on page 26 of your brief you said if it's a responsible court, it would in effect rewrite this statute contrary to what you concede to be its plain language and intent? But a court would do that rather than the Florida legislature?
The court has two choices in that situation. It can either nullify the statute, in which case it is totally thwarting the legislature's will, or it can modify the statute to meet the constitutional equal protection requirement. If it guesses the wrong way in either direction, the legislature, of course, has the final word. But the court faced with the question, should we take this exemption away from the 3/4 of the population, the widow population that now gets it, rather than extend it to the 1/4 that doesn't, in order to preserve what the legislature did do? It seems to me it's eminently more destructive of the legislative will to say that we remove this exemption altogether than to say we'll keep what you wanted and then add this much smaller group.
I might agree with that. Excuse me, Mr. Chief Justice. I was going to say I could be persuaded, I think, to agree that it would be more constructive if you prevail here for the legislature in the end to equalize it. But I was curious by your suggestion that the court itself could rewrite a perfectly plain statute conceded by you to be plain.
A number of state courts have done just that. We cited Small against Pusey,
I
for
didn't know it was
example.
going that far.
These were all cases where a statute was constitutionally infirm because of under-inclusion. A group had been left out, and then it was the court's choice to determine whether it wanted to knock out the provision altogether or to do, as Mr. Justice Harlan once put it, the choice is between amputation and a skin graft.
That's what he suggested in Welsh, but
Yes.
the court's never done that, has it? Isn't that was his point of view?
That was a concurring opinion.
Yes, but that was the fifth vote and determined it.
Yes.
Well, incidentally, I gather you recognize your suggestion at page 25 of your brief that if we agree the statute's unconstitutional, that we should remand for consideration whether consistent with the dominant legislative purpose, the constitutional infirmity should be remedied by holding the exemption available to all widowed property owners. We wouldn't do that, would we? All we would do, if we agreed with you, would be simply remand for proceedings not inconsistent with this
Exactly
thing,
right. Yeah,
without making any suggestion.
That's quite so, yes. What we seek in this court is a declaration that the gender line is unconstitutional, that it is unconstitutional to exclude widowers, and then a remand for further proceedings not inconsistent with that opinion.
Is that the only way we could do it, or could we simply say the statute's invalid, period?
I think that you would be clearer and provide more precise instruction to the Florida Supreme Court if you said that the statute was unconstitutional insofar as it excluded widowers.
You take the risk I'm speaking in broad terms, a litigant takes the risk of destroying an entire statutory scheme when they attack it in this court as one of the risks. Is that not so?
Justice Brandeis once made the point that when a taxpayer is in this situation, that taxpayer cannot be expected to have his situation equalized by asking the taxpayer to increase the taxes of others similarly situated. So that when a taxpayer is subject to a discriminatory tax through favoring others, the only equalization possible is to grant that taxpayer the exemption accorded to others, and then the change for the future can be made so that all persons similarly situated will either be included or excluded from the exemption.
But you still agree we cannot do that?
I think it is the province of the Florida Supreme Court to decide what should be done with that Florida statute.
But are we obliged to suggest to them what they should do, or can we do anything more than hold that statute unconstitutional? Can we do anything more?
Well, you can do what Justice Brandeis suggested in the Iowa Des Moines case, 284 U.S., and that is to say that this appellant must be granted the exemption because there is no other way that his claim of a denial of equal protection can be redressed.
Which is entirely different from this case. The exemption in that case is entirely different.
It was a different kind of exemption, but the same situation
Not as I remember it. But wouldn't we be rewriting the statute?
No, you wouldn't be rewriting the statute. You would be holding that the statute contains a constitutional defect, that the classification...
No, if we say that you must include the others, we wouldn't be rewriting the statute.
You would not be rewriting the statute for anyone other than our claimant who made a timely claim for this exemption and to whom the denial of equal protection cannot be redressed in any other way.
Call that a minor repair of the statute?
Would call the extension of the statute to widowers a minor repair, yes.
Necessary repair.
A necessary repair to preserve its constitutionality, yes. Okay.
I think we'll not ask you to spend 1 minute dividing your argument, counsel. We'll let you start fresh in the morning.
Very good, John.
We'll resume arguments in number 7378. Mr. McKenzie.
Mr. Chief Justice, and may it please the Court, because of the part of the argument yesterday, I feel that it's necessary at this time to clarify some of the facts of this case. This is a claim by a widower that he has been denied equal protection of the law, both by a mandatory self-executing provision of the Florida Constitution and by a statute providing exemption from ad valorem taxation of property to the value of $500 yearly for widows but not for widowers. Now, that's important for two reasons. One, first of all, counsel in argument yesterday stated that this was a deduction from taxation. In fact, it's not a deduction, it's an exemption to the amount of $500, which in dollar terms, translated through the assessment laws of Florida, comes out to about a $15 dollar amount. Secondly,
what difference does that make?
We don't make a de minimis argument. I simply wanted to clarify the fact that it is not a $500 deduction from tax, but...
I thought you were making a distinction between a deduction and an exemption.
That's right. That's right.
And I ask, is there a difference?
Yes, there is a difference. The exemption is from the ad valorem value of the property. In other words, if property is worth...
I know what it is, but I'm asking what difference does it make?
It makes a difference...
makes a difference of about $485.
That's right, Your Honor.
But what legal difference does it make is what I'm trying to get at.
No legal difference as far as this particular case. I merely wanted to clarify the fact, Your Honor. Secondly, it's a $15 benefit. I was merely trying to put it in perspective.
Actually, if the $500 were actually deductible from the tax bill, you'd refer to it as a tax credit, wouldn't you?
Yes.
Well, yesterday we had another case involving all kinds of millions of claims of $3 to $10, but the case was here just as well.
Yes, Your Honor. And we're not making an argument that the case should not be here. The other question...
I'm sure you'd rather there weren't.
Yes, Your Honor. The other question, though, is of more significance, and that's the fact that we are dealing with, as I say, not simply a statute, but a provision of the Florida Constitution. And this is significant in that, as we noted in our brief, we know of no case providing for this court or the Florida court to expand a provision of the Constitution to include members of a class who are not included in the class where there is no ambiguity. And I think that's important in the discussion yesterday of whether it could be sent back to the Florida Supreme Court for the purpose of expanding the class in the statute. It isn't simply a statute. It's a Florida constitutional provision that we're dealing with.
Well, as I understand it, the ultimate conclusion was that Mrs. Ginsburg, I think, acknowledged that that wasn't for us to do, that the limit of our function here was to uphold the provision of the Florida Constitution and statute or to invalidate it. And if it's invalidated, it would be remanded to the Florida Supreme Court to do with our decision what it will.
Very good. They've made a strong argument in their briefs
as to what the Florida Supreme Court ought to do, but that's not for us.
Basically, the state of Florida has two positions. First of all, that the compelling interest test of the frontiero plurality should not be applied to sex classifications. And secondly, that the classification of widows to the exclusion of widowers in view of the purpose and the factual realities of this situation does not, as applied to the appellant here, violate the equal protection either whether tested by frontiero in the plurality or by the standard in Reed, if in fact that's different from traditional standards, or by traditional tax classification and sex standards. And I'll address myself first to the traditional test, because I feel that under that test it's clear that the distinction here meets the test. First of all, the classification we have is a classification of widows and widowers. And the question is, what is the purpose of that classification? The state of Florida, as noted by the Florida Supreme Court, recognizes by this classification that women, and especially widows, are an economically disadvantaged class in our society. This is not in line with past cases where stereotypes were developed for the purpose of so-called protective legislation for denying women something on the basis of a stereotype that wasn't backed up by facts but was backed up by beliefs that people had, by mythology, really. It's not based...
Class?
Widows?
Widows, yes, I would say that widows,
I thought the statistics were all of the contrary.
the statistics are the contrary. The widows are the contrary. The widows are economically disadvantaged.
Anything but an economically
Well, I think my brother Brennan is referring to the fact that widows own a great deal of the property in the country, but that is because there are many, many, many more widows than there are widowers.
That's right. I would agree with that.
Some widows are don't have any money, and others do.
Well, but basically the fact is that taking a widow and a widower, the general facts are that a widow has a likelihood, if she must transfer into the job market, of not being able to earn as much as the widower, simply, if for no other reason, that the fact is that women in general are only earning 60% of what men are earning.
You mean they're discriminated?
They are discriminated against. And I think it's a recognition of that fact. The Florida statute merely and constitutional provision merely recognizes that women, not because of any inherent problem with women, but with an inherent problem with our society that hasn't been corrected yet, are in fact discriminated against.
Does Florida give any other provision and benefit of women in their taxation other than this?
Other than this particular
Yes, sir.
provision?
Because I would assume that the widow, before she becomes a widow, if what you say is true, she suffers a lot too. Does Florida recognize that in this taxing scheme?
Women other than widowers?
Uh-huh.
I'm not familiar with any provisions.
Well, why single out the widows?
Well, it was the will of the people in adopting the Constitution of the
Well, on the
Florida.
fact says when the Constitution was adopted the same as they are today.
Pardon, Your Honor?
Were women allowed to make contracts when this Constitution was first adopted?
This Constitution was adopted in 1968, Your Honor.
Wasn't that provision in before then in the old Constitution?
Yes.
And it was just carried over. I'm talking about when was it originally in the Constitution?
1885, Your Honor.
Well, aren't women in a little disposition now than they were in 1885? A little?
In a better position now than they were in 1885? Yes, Your Honor. But clearly they're not, by any means, have been given economic equality in the society. And I think this is a recognition of that.
But how can you put them in a class? I would assume that there's some widows in the Palm Beach area that are a little better off than some widowers in upper part of Florida.
Well, I think the law has always recognized that no class is going to be perfect. Even if we took a $4,000 limit and said anyone who earns $4,000 or less should get a $500 exemption.
And I assume that's especially true in taxation. I assume that's what you said.
Yes, Your Honor. We still have the problem of saying that there are people who earn $4,000 who have no dependents, and there are people who earn $4,001 who have 10 dependents and are much more needy. Obviously, for the purpose of taxation, the states have never been called on to treat every case on an individual basis, and I think that the court would recognize that that's not a practical possibility.
I'm just trying to get the reason for this singling out. You agree this is solely on sex?
I would say it's sex as tied to economic reality. In other words, the class is not simply actually.
Well,
the class
what's the difference between a widow and a widower other than sex?
Other than sex?
Yeah.
One, the fact that a widower being a man is recognized as having greater earning potential in our society.
To become a widow?
Pardon?
There's no way for a widower to become a widow.
No, there's no way.
So it's sex. What's wrong with admitting it that it's based on sex?
It's based, but see, to say that it's based on sex is accurate, but it's based on sex plus an underlying recognition of a factual difference between the sexes and not simply a stereotyped difference between men and women.
Is this the same Constitution also prevented women from serving on juries, didn't it?
Yes, it did, Your Honor. the law of Florida prevented women from serving on juries.
But now they do.
Or it didn't prevent women from serving on juries.
Now they've been persuaded to let women serve on juries.
Women were not prevented from serving on juries. They had to take affirmative action to indicate that they desired to serve on juries.
Back in the 19th century? In the original
At the time of the Hoyt case, Your Honor.
In the time of the original Constitution?
At the time of the original Constitution of Florida, I'm not prepared to say, Your Honor.
Mr. McKenzie, are you suggesting that this is based on economic need?
Yes, Your Honor. I'm suggesting that this case is very little different than Grunwald versus Gardner.
Well, if it's based on economic need, why doesn't it say so instead of putting it on widowhood?
Well, because I think it recognizes the underlying rationale. The class is not simply widows. The class is widows, the blind, and the totally and permanently disabled. I think that all of those have the same line of reasoning running through them for different reasons. But disabled are economically disabled.
It works to benefit the wealthy widow in Palm Beach.
It works to benefit the wealthy blind person also.
The wealthy widow in Palm Beach, and to disadvantage the poor spinster in Tallahassee.
Right. But the fact is that as a general objective analysis, women and widows are not in the same economic classification as are widowers. They don't have the same opportunities. First of all, a woman who is a widow is either one of two possibilities. One, she's the head of the household, the same as a widower. And in that case, the distinction is exactly as I've said, that she does not have, as a general rule, the job opportunity that the male does. The other case is where she's not been the head of the household, and the widow and the husband is the one that dies. And in that case, she not only has to move over into the job market, but she has to get someone to replace her and take over the duties that she had, which is really a double burden compared to the man whose wife dies, who simply has to replace the functions that his wife had in the family unit. She has to do both that and move over into the job market.
And if she moves over into the job market for the first time at age 55, I suppose her lower earnings compared to a widower who may have been in the market for 30 years aren't necessarily attributable to discrimination. She simply hasn't been in the market.
She hasn't. Well, I would agree that they aren't. That's true, but they're even compounded by discrimination in that the job opportunities, not only to an elderly person, but to her particularly, are greatly lessened, both by her age and by her sex. Now, as to the general classification, the traditional test, first of all, if the court is to use that test, and we would submit that it would be appropriate, in all the tax cases, where there are tax classifications, there's a presumption of constitutionality, a heavy burden on one challenging the classification to show no conceivable permissible basis, and it's been recognized that the classification need not be exact or have mathematical nicety. Clearly, if the no conceivable rational purpose test is to be used, I'd submit that the appellant here has not met that burden. Not only is there a conceivable rational purpose, I submit, but the purpose that we've offered to the court is in accordance with a proper tax purpose, concern for the economically disadvantaged groups in society, and that's a valid social concern. Secondly, under Reed versus Reed, it's possible that case could be read to say that there is an additional burden that the court is going to place on the state where it makes a classification, and that's the burden of justifying a rational classification. And I submit again that that we have not relied on stereotypes that women are either physically not capable of doing the work that men are capable of doing, or the women are in some way because they're the creator of children, that they should stay at home. We're not saying that. We believe that women have all the rights that men have, but that the facts of our society are that women have not yet been given those economic rights, and that until they do, it's appropriate for the state of Florida to have legislation which recognizes that and gives them an affirmative chance to pull themselves to attain equality.
$15?
Well, Your Honor, the fact that it's a small amount is true, but to argue that the state of Florida should give more, that the determination of the people of Florida was that it was an appropriate gesture, and it was
might enable her to retain the ownership of the
and
property rather than
the fact is that someone at a low level of income,
$15 annually on a real estate.
May enable them to retain property which they would otherwise not be able to retain. While we submit that the plurality opinion in Frontiero should not be applied, I would submit that based on that decision, the classification that we've established is sufficient. That case specifically in the footnote refers to, in a footnote 22, I believe it is, states, it should be noted that these statutes, and those are the statutes in Frontiero, are not in any sense designed to rectify the effects of past discrimination against women, citing Grunwald versus Gardner and Jones versus Mayer and South Carolina versus Katzenbach. And on the contrary, these statutes seize upon a group of women who have historically suffered discrimination in employment and rely on the effects of this past discrimination as a justification for heaping on additional economic disadvantages. That isn't the case that we have here. The second is not the case that we have here. There is no purpose nor result of heaping additional economic disadvantages on women. There is a purpose of taking affirmative action if indeed women are to be determined to be a suspect classification, to reduce the results of past historic discrimination. So that even under Frontiero, I would submit that it would be appropriate to approve this classification. However, I think it's well to point out to the court that, and we submit that this court has, in general, limited suspect classifications to groups which, since that have been described since Caroline Products as discrete and insular minorities. And I would submit that a classification based on sex does not have within it a discrete and insular minority. Whether be it the plaintiff here who is a male seeking to have the statute applied to him or else struck down altogether. Clearly, the male is not a minority in a group where men and women are equal. And if women are anything, it would be, I guess, a philosophical minority in that they've been discriminated against. But I know of no case where the court has found that a philosophical minority qualifies for strict scrutiny. And I think it's proper because any group that is a interest group is a minority, and it may not get everything it wants out of the judicial process. And it's not for the court every time some group, other than a racial classification or an easily identifiable classification like that, comes before the court to give strict scrutiny to something that doesn't, to a statute that doesn't that interest group what it wants. And on those grounds, Your Honor, I would submit that this classification should be upheld.
Mr. McKenzie, this
Yes, sir.
is a property tax. Is this a tax imposed on both real and personal property, and as well as mixed, or is this just a real property tax we're talking about?
This is no. It's a tax on both real and personal property. It's on the ad valorem taxation, and ad valorem taxes in Florida are both on real and personal
Real
property.
and personal property. And how is it? How is property appraised down there? What's the assessed valuation? How close to
assessed at
realistic
100
market value?
It's by Constitution. It's to be assessed at full market value.
Well, what's the
100%.
practice? We all know about those.
Well, that's in the courts now as to whether, in fact, it is assessed at 100% of market value. In fact, it's I would say assessed between 80 and 100% of market value.
Mm-hmm. Does it vary by counties?
It varies by counties. That's
Usually
right.
does.
The assessors in the counties do the assessing.
Mm-hmm. So this wouldn't.
However, it's to add to that, all assessments are reviewed for the purpose of equalization by the Department of Revenue of the state of Florida, so that theoretically, it's when they approve it, it's a determination that that county is at 100% of assessed value.
The reason for my question is I was wondering whether this exemption could validly be supported as a provision that might enable a widow to keep her family home after her widowhood, rather than having to sell it at a distressed sale if this were a real relief from the real estate taxes on that home. But it hardly is enough, is it?
Well, the question is where do you draw the limit? It might be enough for one widow.
Well, I know.
It might not be enough for another.
$500 is, and that's the reason I asked how close to realistic market prices are your actual appraisals.
Theoretically at 100% of assessed value.
What's your typical tax rate on real property, say in Dade County?
The rate would generally be 30 mils, which would translate into the 30 mils would translate into a $15 exemption under this.
Well, on a house assessed at $20,000, what property tax would you pay in Dade County?
That's right.
$600. How much?
$600.
At 30 mils, that's $600.
That's right, yeah.
McKenzie, in your brief, you point out, relying on Bureau of the Census figures, that 35.8% of the families in Florida in which a female is the head of the family are below the poverty level, whereas I think it's about 9% of the men who head families
That's right, yeah.
are below poverty level.
That's right, and I think that's
Are those figures unique to Florida, or how would they compare with national?
I would imagine that they would. I really can't answer that, Your Honor. Those figures were drawn out because we were especially concerned with the Florida situation. I imagine that they would probably be typical. I know of no situation in Florida that would make them atypical on a national basis, but I can't represent that to the court.
Well, you don't have many of those owned in homes, do you?
Pardon?
You don't have many of those owned in homes.
The ones below the poverty level, Your Honor?
They're mostly renters, aren't they?
Not necessarily in Florida, Your Honor, because you have a lot of very poor people that are in that own property and that they own mobile homes. That's the typical situation in Florida, much more so than any other state. I'd say a much larger percentage of those than in the typical state would be in a position where they were in property ownership.
It wouldn't be true up in the Turpentine area.
I'm sorry?
Up in the Turpentine area, up near the Georgia border, they don't own anything up there.
Well, I live in the Turpentine area, as you call it, Your Honor, and it's not so much as the rest of the state, but certainly it's a mobile home area the same as in the other part of the state, although it's not so much of the elderly living there. So that's part of the problem.
But it ranges from the lower person to the highest anywhere you go. You admit that, and
Yes, Your Honor.
You say that's normal for taxation, and in some areas it is. It's just the question is whether it's normal here where you draw the line on sex.
Yes, Your Honor, we submit that this statute is this statute and constitutional provision are a recognition of the economic realities of the state of Florida. Thank you, gentlemen. Thank you.
Thank you, Mr. McKenzie. Mrs. Ginsburg, do you have anything further? You have about 2 minutes remaining.
First, I would like to qualify that mobile homes are not subject to the ad valorem property tax. Article 7, Section 1 of the Constitution exempts, along with motor vehicles, mobile homes.
Of course, this probably isn't very important, but I know in many states there's an argument about what is a mobile home after it comes to rest,
Yes.
and the wheels come off it. Is it still a mobile home?
Also, I would like to qualify the statement made that this tax is subject, real property and personal property are subject to this tax. That's true in the constitutional description, but a statute exempts all household goods and all personal effects for all persons, whether or not they're heads of family, and that's Florida Statute 196.181. In fact, the legislature has twice extended this constitutional provision that we're talking about by ordinary statute. And then finally, with respect to a point that came up yesterday, recent models for the disposition that appellant seeks in this case include the per curiam opinion last term in New Jersey Welfare Rights Organization against Cahill, earlier Mr. Justice Blackmun's opinion in Graham against Richardson. Both of those opinions dealt with constitutionally under-inclusive state rather than federal benefit statutes. And both are cited at page 27 of our main brief and in the footnote at page 8 of our reply brief.
Professor Ginsburg, could I ask a question? You're familiar with the DeFunis case to be argued this afternoon?
Yes.
This perhaps is an unfair question, but does your position in this case, with respect to the Florida classifications, bear in any way on the issues in DeFunis?
Not at all. The DeFunis case raises a very different issue. DeFunis is a program of a law school that is designed to open doors to equal opportunity, to assure a law student body with diverse backgrounds and experience, and to rectify the conspicuous absence of minority groups from the profession. It is not a welfare dole based on the assumed inferior capabilities of any population group. No rigid race line is presented as we have here, a rigid sex line. Race is merely one of many characteristics assessed in that case. But most significantly, DeFunis involves no general law classification. It's a measure addressed to the very special selection problem that law schools have. Law schools have the very hard task of choosing some from among many applicants that are equipped to pursue their educational program. By contrast, here we are dealing with a law of general application, a law with respect to property owners, where there can be no justification for the crude device of labeling any group, racial, ethnic, or sexual, as needy persons. An income test is readily available to a legislature that wishes to distinguish on the basis of need. An immutable birth characteristic should be irrelevant for general law purposes.
Thank you, Mr. Ginsburg. Thank you. The case is submitted. We will hear.
3-78 Kahn versus Shevin, here on certiorari to the Supreme Court of Florida. Florida has a statute that grants widows an annual $500 property tax exemption, but does not extend that exemption to widowers. And the appellant is a widower who brought suit asking for a declaratory judgment from the Florida court saying that the statute violates the Equal Protection Clause of the 14th Amendment. The court held contrary to the claim of the widower, and we affirm that judgment, finding no invidious discrimination. Mr. Justice Brennan has filed a dissenting opinion in which Mr. Justice Marshall has joined, and Mr. Justice White has filed a dissenting opinion.